morning, Your Honor.
Good morning, you may be
Please
seated.
have a seat. No cell phones on, off and away. No talking, please.
Before we begin, any objection to the media?
No, Your Honor.
Not mistake. Madam Kimberly Sullivan, 2 on the Part A regular docket.
Good morning, Your Honor. Ioannis Kaloidis on behalf of Ms. Sullivan. She is present and approaching.
The state's filed a motion to modify the defendant's conditions of release. We are in receipt of the motions from the defendant in response. I would like to point out for the record that Connecticut Practice Book Section 3813, 3814, and Connecticut General Statutes 5469 and 5469B, and the relevant case law from the statutes, gives this court the authority to modify conditions of release at any time. I disagree with the defense. There has to be a change in circumstances, and the court always has authority. The state is renewing its request for EMS monitoring and house arrest, and in the alternate, GPS monitoring. The state's also requesting that the defendant, if she has a passport, it be surrendered. The state still submits to the court this defendant is a substantial risk of flight. She faces the rest of her life, or a significant period of the rest of her life, incarcerated if she's convicted of these charges. That makes it a significant incentive to flee this jurisdiction and to not appear in court. If it's come to court, face the charges, and if she's convicted, face the rest of your life in jail or flee, I think it's a pretty simple alternative, an equation would permit her to flee. This is a strong case for the state. The court has read the arrest warrant. But in addition to that strength, since the media coverage of this case, several additional witnesses have come forward. For example, a friend of the defendant's of 21 years has come forward and provided a written statement to the state, to the police, that in the 21 years she's known this defendant, she's never spoken of a stepson. She was shocked to learn she had a stepson, and that son was never allowed in this house. Additionally, I'd like to point out to the court, it's a domestic violence case. With a domestic violence victim, the GPS monitoring or EMS house arrest is often imposed for far less serious crimes in domestic violence matters and other matters. Since the arraignment, the state has had an opportunity to meet with this victim. This victim is afraid. This victim lives in fear. I introduced myself to the victim, explained who I was. His first question in this fear is, why is she out walking around when I was locked up in her room for 20 years? He is following this on TV and social media, so he is aware of what's happening, and I say that because it would lead to his fear. Based on all that, the state is asking for those conditions.
Your Honor, I respectfully and vigorously object to the state's motion. I believe it is improper, and I believe if it was to be granted, it would be unjust and a violation of my client's state and federal constitutional rights. This is the third time we are back addressing the same issues. Bond has been set. Conditions of release have been addressed by the court. The state made essentially the same arguments on prior occasions, which were considered by the court and rejected by the court. We are back now, 2 weeks later, giving the state another bite at the apple. And the court was clear on March 13th when the court rejected the conditions that are being sought. The judge at the time made clear she was rejecting those conditions and made clear that we would keep this on a short leash, basically, come back in 2 weeks or whatever, and if there were any violations, she would reconsider. A defendant must be able to rely on the representations and the orders of the court. And when a defendant is told, you will be released under these conditions, and if you abide by these conditions, you'll be fine. The only thing that has changed is now we have a 2-week track record of compliance. That is the only change that I have seen. That is the only documentation that has been provided to me, or that I've been able to see so far, is a report from bail indicating a track record of compliance. So the only thing that has changed in the eyes of the defense with respect to the case is that my client has been complying with the conditions and has done what has been asked of her. Despite the fact that she's complied with the conditions, we're now back seeking to add additional conditions. And I understand that the whole world wants to convict Ms. Sullivan, and the whole world already has. But this is the only place, the only room in this country where we have an opportunity to protect her rights. And as unpopular as that may seem, that's what's at issue here. Her rights, no one else's. When we talk about the constitutional rights in criminal law, they're to protect the accused, regardless of how unpopular it may be. So, Your Honor, I think it would be, respectfully, Your Honor, I think it would be a mistake to add conditions at this time. And I filed a supplemental memorandum. And although it's my supplemental memorandum, I think to some extent it is the strongest argument and one the court should be the most concerned about. And that is protecting my client's right to a fair trial. She is presumed innocent. Maybe not to the rest of the world, but this is the one place where that presumption should remain. And by adding conditions, the court is sending a message that she has done something wrong, or the court feels that she has done something wrong, or the court feels that something has changed to increase the conditions of release, increase her monitoring, when none of that has occurred. So by granting the state's motion, a message is sent to the world that the presumption of innocence means nothing. And that cannot happen, Your Honor. And the presumption of innocence is tied to bail. I cited the Troconis case, which cites a U.S. Supreme Court case, which talks about the importance and how the presumption of innocence ties into bail. The whole world is watching. And if we add additional conditions now, we are sending a message that she has done something wrong, or that the court believes she has done something wrong. I, as her attorney, stand by her. She is presumed innocent, as unpopular as that may be. Now, getting back to my original arguments in this, Your Honor, the court on Wednesday referenced the Ayala case. And I looked at the Ayala case, and this is distinguishable. Yes, the court has the inherent authority to set conditions and modify conditions. Just because the court has the authority doesn't mean that it should exercise that authority. And I'd ask the court not to exercise that authority. In Ayala and in all the other cases where there's been a review of a court adding conditions or revoking bond or impacting bail, there has always been something to trigger it, some violation of condition of release, some concern that the defendant will not be able to appear in court or is a danger to anyone else. She has appeared in court despite the difficulty in getting here. There are serious safety concerns for her. Putting her in a specific area where she cannot leave will only create additional safety concerns. There are numerous threats against her. Numerous people have made threats. They're posting them online, talking about not waiting to be able to see her out in public. She needs to be able to have freedom of movement, and at times, in fact, Your Honor, I've actually advised her to leave the state initially, given the media attention, for her own safety. If the court was to put her on a GPS monitoring bracelet, she would not be able to do that. If the court put her on an EMS, she would not be able to leave the residence where she is. That would create additional safety concerns. Getting back to the law here, though, Your Honor, I think the Ayala case is clear that there needs to be, I think it calls for some type of violation. Whether you call it a change of circumstance or not, that's something that had been used, an argument that has always been raised in our state courts here, and I believe it is an appropriate consideration, Your Honor. Your Honor, my motion also details her ties to the community, all the things that the court's already considered in setting the appropriate bond here, Your Honor. Everything has been considered by the court, it's been evaluated, and there is nothing different. I understand there's a lot of public pressure, and the public sentiment may be that there should be more conditions on her. But the bond that's set is appropriate, the conditions that are set are appropriate, she's abiding by those conditions. The state has argued this before, it has been rejected. There is absolutely nothing new other than a positive track record. Your Honor, respectfully, I cannot understate how strongly I feel about this. I do not believe any change in the conditions of her release would be appropriate right now. I believe they would have a direct and significant impact on her right to a fair trial, and I believe it is a dangerous message for the court to send, and it is one that will impact and bear directly on the presumption of innocence, which is something that is crucial in this case, because nobody has afforded her that. And we look to the court to protect that. Your Honor, respectfully, I ask the court deny the state's motion.
All right, we're here today on the state's motion to add conditions of release, specifically either EMS house arrest and/or GPS monitoring, in order to reasonably ensure that A, she appears in court, and B, to protect the safety of the public. And in making this decision, I'm instructed by General Statute 54-64A, subsection D2, to consider the following factors when considering any conditions of release. And I'll just go through them one at a time. First, the nature and circumstances of this offense and the seriousness of the charges against her. There are 2 B felonies. One of them carries mandatory minimum jail time. There are other felony charges against her, in addition to that, misdemeanor charges. And the allegations are arguably the most troubling that I've seen during my tenure as a judge, and show really an unthinkable amount of a lack of empathy. And I do stress that they are just allegations at this time. 2, her past record of appearing in court. She has no prior cases, no prior failures to appear in this case. Her family and community ties to the area. She has 2 daughters in the area, and I believe she is temporarily living with them, but she has no permanent address. We learned that since the last court date. As far as her employment record, to my knowledge, she has worked for the majority of her life, most recently at JCPenney. As far as her financial resources and her mental health conditions, I'm not aware of her financial resources at this time, but since the last court date, it has come to my attention that she was admitted to the hospital to address certain mental health conditions. As far as the weight of the evidence, we haven't pre-tried the case, there hasn't been any discovery. I don't know how strong the case is for the state at this time, but since the last court date, according to Attorney Thurkelson, he has spoken with the complainant more, learned additional information about the case, and additional witnesses have come forward. So from the state's perspective, it has gotten stronger. Whether she has been previously convicted of similar crimes, again, she has no record, so she hasn't. And the likelihood that she would commit another crime if she is released, which she has been, but as far as the GPS and the EMS conditions. On the one hand, she has no record. So you could easily argue that if she has no record to date, she is unlikely to commit any crimes while she's released. On the other hand, I can see the argument that someone who could show, again, just according to the allegations, someone that could show such an extreme indifference to human life, such a lack of empathy, if that person could commit that type of crime, they're certainly likely to commit another type of crime. So in considering all of these factors, most specifically, the serious nature of the allegations and her additional mental health conditions, the mental health conditions in particular, since we learned from the last court date, as well as the fact that we've learned that she has no permanent residence at this time, I think putting GPS monitoring on her is appropriate to protect the public and to ensure that she comes to court. However, I am denying the state's request for EMS house arrest. I don't believe, given the factors I considered, that that is wrong. As far as the next court date or any additional issues?
Your Honor, May we enter a not guilty plea and make a jury election today?
Yes, noted for the record.
With respect to a next date, Your Honor, is April 29th acceptable?
The state would ask for a shorter date.
What date in particular?
I would like 3 weeks, one to monitor compliance, two to update the court in our discovery process.
Right, you want to say April 15th,
I'm away that week, Your Honor.
22nd?
I have a conflict that day, Your Honor. Can we do the 21st? Actually, Your Honor, we'll make the 22nd work. I can juggle that.
And I'll leave you with this. I agree with your attorney. These are just allegations. You are not guilty. You have the presumption of innocence. You will get a fair trial. The reason I put GPS monitoring on you has nothing to do with you being guilty. It shouldn't be interpreted that way. We get discovery of the state of the game April 20th, and we'll recess for the next 20 minutes.
All right.
You're going to walk with me. We're going downstairs. Get our section documents.